Also, an amount paid in violation of a law, when subsequently recovered, does not clear the person who gave the approval to be made of criminal wrongdoing in the first place.
Samson, first of all, let's agree that there is a vast difference between Godfrey Dame and Dr. Ine. In terms of, I'm not talking of the fact that one has a PhD and one doesn't. That is not what I'm talking of. I'm talking of the very appreciation of personal liberty.
PhD is important. Some of us have run away from it. It's not an easy job.
Well, but that's not my point here.
Okay.
I mean, the very appreciation of personal liberty is important here. You and I have been on this criminal defense for some time. What goes into a person waking up every morning and coming to court, being called, cases being adjourned, the cost, you can't do anything because you have to be in court. I mean, we just talked about someone who has been declared as a fugitive, right? If you have respect for personal liberty, you will not sit and argue that, well, if you think that the person is innocent, why won't you allow him to go through the entire trial for him to be declared innocent? When you know, as a prosecutor, exercising your professional judgment, that this cannot lead to conviction. We're talking of a
in that case, what happens to Justification? Because Chachuchikata says, this is my case, I want my client to prove his innocence, the Attorney General says, well, I left that one, but I wanted to file another prosecution.
Let me just continue from where I left off, and I'll answer that question. For example, you have a memo which has been given to you. I know the former Attorney General said that he never had any memo. That cannot be true because the records, and I will encourage you to apply under the right to information laws to the Attorney General's department. And you will see copiously that there is clear record of the Attorney General the former Attorney General, having been, served with a memo which clearly says that this case conviction cannot be possible. And yet, he gave comment on it. He was saying that he never gave comment.
He didn't say cannot, he said may.
Well, at the end of the day, he may. The context, if you put it in the context, he means that he cannot. Eventually, there's evidence that he had a memo, he minuted on it, and took decisions contrary to what the memo said. And what Dr. Ine was saying was that, look, there's no problem if you feel that you can override the DPP, but to deny that indication came to you in the first place, when it did come to you, is to be dishonest. And secondly, look, we are talking of one of the issues that the former Attorney General said was that the AG did not consult the president in taking the decision to what?
Before you get there, you say there was a memo, you minuted on it. Dami wants to know, what did he say when he minuted on it?
He denied that there was a memo. I think that is sufficient.
That's right.
As to what he said, that's why I said that you apply to the ministry.
There's something I have become familiar with,
okay,
and I've already shared with the members of the public. Mm-hmm. What I've become familiar with and the information is that there was the shredding of a lot of documentation.
Indeed.
And that in the course of the shredding of the lot of documentation, it does appear that this particular memo either was shredded or was taken away. But there was a certain trail that has been traced to this memo.
Precisely.
And that's how come there is the one that I have seen and I have shared with the public.
Perhaps the denial...
The one that I have seen and shared with the public does not have minutes. It's not minuted.
The point I'm making is that there is evidence that such a memo exists. There's evidence that the memo was given to the Attorney General. There is evidence that he has responded he has minuted and he has responded to the memo.
The evidence that it exists, I have confirmed that.
So
my viewers.
Up to that point, let's establish that
right.
He lied to the public when he said he was not aware of any such memo. That's what he said.
First, he said it does not exist. Then later, I think he was cautious and said if there was, nothing of the sort came to his attention.
And now all of them are false because it existed, it came to his attention, and he minuted on them and directed the DPP on what to do. And I'm saying that if you doubt what I'm saying, you can apply, and I'm encouraging you to apply to the Ministry of Justice, Attorney General's Department. You may be given a copy.
I've had the opportunity to see. I've not been offered a copy, so I'll try it.
So at least there's a common ground. Now, the point I'm trying to make is that if one of his concerns about the Attorney General was that he took decisions without consulting the president, and that he used his personal authority to enter this nolle prosequi. But that also shows a certain level of misunderstanding of the Attorney General's powers. And I'm surprised that for a former Attorney General, who also served as a Deputy Attorney General, to diminish the extent of the power of the Attorney General, to suggest that every decision that Attorney General is supposed to take, he has to go and take direction from the President. Because the Constitution itself is clear that the Attorney General has two sources of, one is those that the Constitution imposes on him, and those that the President may assign him. These are the two, if you read Article 88. But
these are very important cases, significant on our national economy. You see, the banking collapse crisis.
You see, the Attorney
How does the Attorney General take a decision without recourse to Cabinet?
The Attorney General's office power is sui generis, okay? When it comes to prosecution, because that is what the Constitution says, that it is he decides who to be prosecuted and who not to be prosecuted, whether to continue the prosecution, whether to end it. That is for him. The President may indicate to him that based on this and this, I am assigning this to you, which is also lawfully under the law. That is why we always say that we need to decouple the Minister of Justice from the Attorney General's authority, because the Attorney General, as Attorney General, is a completely different thing. And as in his capacity as a minister, the President may use that power to assign him some work. But to suggest that if an Attorney General wants to enter nolle prosequi or wants to take every decision, he has to go and take direction from the President.
Before we move away,
yeah.
The Johnson Esiama matter, there were two different cases, not one.
Yeah.
Attorney General Dame says that you also sought to confuse both, as if that even if there was a memo, it's in respect of both. But it does appear it will be in respect of one. Is that not it?
The memo was in respect of one. But that is not the only reason why the memo is not the only reason why the nolle prosequi was entered. So if his concern is that the memo is for one, there are other considerations which the Attorney General outlined, that he has assessed the docket, and in his knowledge and his experience and professional capacity, he realizes that these cases were not going to land in any successful prosecution and shouldn't have been started in the first place, and some of which Bright has explained. And those cases must be taken off. Now, this brings me to the next issue of calling the whole thing OCAL. There were 7 cases. About 5 of them had nothing to do with looting. So if you say it is operation...
Still, the memo is referable to the...
One of the cases.
The Unibank case.
Yeah.
Then there is the other case where Johnson Esiama is involved, which is about the UT Bank case.
Yeah.
So how come he gets...
and I am saying
a clean bill for both?
So what I'm saying is that from the Attorney General's explanation given, he did not just base his decision on one document. He said he has assessed the docket, he has consulted with the prosecutors, and he has also spoken with the defense attorneys. And from where he sits in his judgment, he believes that none of the 2 cases were going to lead to any conviction anyways. And he sees no reason for persecuting or subjecting someone to a criminal trial when he knows in his heart of hearts that this is not going to lead to anywhere. So
Bright has just explained here the question of the violation of the single obligor limits, which is the UT matter, which the memo did not cover.
Yeah, the memo
that doesn't make sense to him. But Domkain didn't say this to us, like Bright has put it, that the single obligor matter, it doesn't make sense.
So we need to take the press conference in 8 terms. For example, if you take the Ofusu-Ampofo situation, there was no comment on there was no attempt to explain.
Ofusu-Ampofo and Kweku Boahen, right?
Yeah, there was no. So we should not take the press conference as the totality of the things that, because the press conference had to, when you are doing a press conference, you need to consider the time limit and all that. So we shouldn't just take the press conference as the only decision. But I think we should take the Attorney General's word when he said that from his professional position, he has examined all the dockets, he has consulted widely, not just with the department, the prosecutors in his department, but also with defense counsel and even people beyond that. And he had come to the firm conviction that these cases, and there are many more to come, these cases were not going to lead to any conviction.
There are many more to come.
There'll be more cases that
unprecedented in our history.
Because you see, we should be
that you are entering
discontinuing cases. It is equally unprecedented that it is.
Imagine that another government comes in the next 4 years, and its members are being prosecuted, and they decide to enter nolle prosequi. What are we making of the judicial system?
What is unprecedented is an attorney general who has been partisan for all the years that he's in office and has decided, even without evidence, to persecute people. That is what we should be concerned about, not the person who has come to save the situation. I mean, if you put someone in the criminal justice system and you go to sleep for all these years, and someone comes to say that I have examined what you have done, you have no real basis for continuing this, for starting some of these trials.
If the evidence exists that will not lead to their conviction, and some of the cases are just about to finish, why don't you finish it and allow the court to acquit and discharge them?
That is why I'm saying that.
And it depends on how you... In the Unibank case, the prosecution had closed its case. So the withdrawal means that Johnson Esiama is acquitted and discharged. But in the other one, I'm not sure they closed their case. So it means there's room that in future he may suffer, right?
No one deserves to be put through the ordeal of criminal trial, even for 1 day, if there's no basis for it. So the fact that they have suffered this period does not justify any attempt to say that
there's no basis. Where the courts, in almost all these cases, the courts have come to the conclusion that they have a case to answer, and they are in the processes of answering their case. So how do you come to that conclusion?
If the court was the most appropriate place to determine this, I don't think the lawmakers would give the Attorney General the power of nolle prosequi. They would have just said that once you start trial, allow the court to go. But in the wisdom of those who design our criminal justice system, they have a reason to give the power of nolle prosequi, which could be exercised at any point in time. That shows that they understood that the yardstick that the courts work with may not necessarily be the one that the prosecutorial discretion will be applying. So we cannot say that asking for nolle prosequi means that the courts are not effective or anything like that. We are just saying that to subject a human being, a citizen, to criminal process. I mean, I'm surprised that we are making this comment. We were here.
I'm sorry, but I have to cut you here, and because we are just running.
Let me make this last point.
Let me go to Frank Davis.
No, let me make this last point
quickly in a minute.
Let me make this
in a minute.
Yeah, in a minute. I mean, so I was saying that to tag this whole exercise as OCAL, Operation Clear All Looters. It's actually very unfortunate because the person who made this is my very good friend. And I'm just imagining a day where he would be in this system, this unfair criminal trial, and will now be ordered, when he's given relief, he will consider himself a looter. I mean, what has Ufusampa got to do with any looting? What has Atoforsin got to do with any looting? What has Saglemi got to do? Saglemi was misapplication of the funds. It has nothing to do with looting. Esiama, the evidence shows that the money has been recovered.
But the cases that are being called looting are similar.
No.
Okay. Mr. Frank Davis, let's hear